Hey, William Gilmore here for the ScreenwritersJourney.com, and it is day 42. And today I'd like to talk to you about copyright. Now, this is a subject that I've been wanting to bring up for a while now, but I've been so busy with everything else going on that I just keep pushing it aside and going, it's something that I can deal with on a slow day. But I read an article yesterday looking for things to go on the news page on the website. And this article was by another screenwriter who was offering advice, tips to his fellow screenwriters on different things they can do. Such as, take a few days off after an intense period of writing so that you can come back to your script with fresh eyes. Something I've said before. Basic, sensible tips like that. But about halfway through his article, through his blog, he brought up copyright. And his advice was, forget the Copyright Office. You don't need them. Just go to the WGA, the Writers Guild Association, the Union for Writers, and register your script with them for only $20 and save a bunch of money over the Copyright Office. Well, there's a couple things wrong with that. First of all, the only organization, the only agency that administers and issues registration of copyright is the U.S. Copyright Office at the Library of Congress. No other organization, not the WGA, nobody in the U.S. does that. They're the only ones. The WGA does have a script registration on their website that you can upload your script, send them a file, and they'll give you a registration number. But what this does is basically sort of creates a paper trail for you. It establishes a date of authorship for you on this particular work. It has nothing to do with copyright. It even says so right there on their website that they provide no statutory protection for copyright with their registration. And yet this idea somehow persists that registering with the WGA will protect your copyright. Now, it can help aid in the defense of that copyright because you've started to create a paper trail. And paper trails are really, really good when you're starting to deal with intellectual property. You want to be able to show over a period of time that you had this work, that you were working on this work, that you completed this work, but you need to register the copyright with the Copyright Office, not the WGA. And then there are people say, well, but I don't have to register at all because I am guaranteed a copyright on my work the moment I finish it. As soon as I put it into a fixed form, it has copyright protection. And that's true. You do get copyright protection immediately as soon as you put your idea into a concrete form, whether that's shooting the film or putting it down on paper as a script. That's your intellectual property. But now you've got to be able to prove that. Sure, it's yours, but if you go to court and say, hey, I wrote this script 5 years ago and this company produced it, how are you going to prove that? Well, I've got the script sitting on my desk. It doesn't mean anything. Registering your copyright with the Copyright Office establishes that date. You can even sort of predate that or post-date it. If you, say, worked on a script in 2010, didn't like it very much yourself, then I'll come back to it. You did a bunch of other projects. Now 2015, you go, I want to work on that project. So you pull it off the shelf, you start to work on it. My God, it's brilliant now. You're ready to go with it. And you go to file your copyright. You can put on the form that your initial completion of this project was back in 2010. And this is an update of it. And that establishes a time frame for you. If you have to go to court over that, you may still have to be able to prove that 2010 completion, either through emails or some other type of documentation, but you can do that. With the WGA registration, you can't. It's from the date that you send it into them. Also, the WGA registration is only good for 5 years compared to the copyright registration with the U.S. Copyright Office is for the life of the author plus up to 120 years depending on the nature of the project that's being copywritten. After 5 years of the WGA, you're going to re-up again. So you got to pay the same price. So that if you're arguing that the WGA is cheaper, it's $20 versus $35. $20 for 5 years or $35 for your life plus 120. And there's only a difference of $15 there. So that's not even a bad night at the bar. That's basically a brew on the way home. So going with the WGA, after 5 years, you've got to re-up that or renew that registration with them for another $20. So In 5 years, you've paid twice, $40. You've already exceeded what it costs to do the registration at the Copyright Office. So you're starting to fall behind on saving the money thing, and it's a long-term issue. There's also a problem with renewal, and then if you miss the renewal, WGA tosses your work, tosses all those records, and they're moving on because you didn't bother to renew. And so you lose your paper trail. Whereas if you had gone with the WGA to begin with, with the Copyright Office to begin with, you'd have that paper trail in perpetuity. So it's not that you shouldn't register with the WGA. That's a great addition to, because it does help establish your authorship in 2 different locations. You've got the WGA and the Copyright Office, but if you can only do one, do the Copyright Office. And then someone else, right after I read this article, posted in a forum and said, yeah, but if you go with the WGA, then a producer or a studio can't mess with your work. They can't change a word of it. No. I could hear the laughter all over the internet on that one. If you sell your script to a studio or a production company or a producer, it's theirs. You have given up ownership in exchange for money. So they can do pretty much whatever they want. And the first thing they're most likely to do, bring in another screenwriter to rewrite your work. And if that writer does substantial changes, he can petition, and this is assuming that it's a WGA sanctioned production, he can petition the WGA for sole screenplay credit. And it'll go into arbitration and mediation, and they go back and forth with the producers, and they look at everything, and you may be relegated to a story by credit as opposed to a screenplay. So once you sign over those rights, they can do whatever they want with it. So that's no protection there. Going to the WGA does not protect the integrity of your work. It just merely establishes a date of authorship. Another very popular myth that really needs to be addressed and crushed is the idea of the poor man's copyright. And this is where you take a manila envelope, put your script in it, address it to yourself, go to the post office, get a postmark, send it to yourself, and then put it on the shelf once it arrives. And then if anything ever happens, you go to a lawyer and go, hey, this is my script that so-and-so ripped off. And it's right here inside this envelope with a postmark showing that I did this 10 years ago, or whatever it is. And the lawyer's going to go, that's great. Do you have your copyright registration? You go, no, I sent it in the mail with the postmark. What can I do with that? There's no case law that supports the poor man's copyright. And this is something that I hear all the time. You go to screenwriting conferences and they'll have speakers or lawyers and someone in the audience, what about the poor man's copyright? And he'll say, no, it doesn't exist. It's not, there is no basis for it. They're not even going to accept this as a paper trail, as evidence to be submitted in a court, because it's too easy to fake. You can take an empty manila envelope, address it to yourself, put the right amount of postage on it, get that postmark and send it to yourself. And 5 years from now, Warner Brothers, Paramount does a big blockbuster movie. You get a copy of the script, make a couple of changes so it's not completely exact. Slip that into your envelope, seal it, and then go to the lawyer and go, hey, I've got this script that I wrote 10 years ago. Not that you would ever do that, because that would be illegal and ethically very challenging. But because it can be done, because it's so easy to fake, it's not a legitimate piece of evidence to submit in a court of law. So it's bunk. It's pointless. It's useless. It's worthless. Don't do it. Spend the $35. Go to the Copyright Office. Register your work. You're a professional. You're in show business. This is part of the business. You've got to do it. Do your due diligence. So why would you do the WGA registration? Well, like I said, it's something to do in conjunction with your copyright registration with the U.S. Copyright Office. But the Copyright Office can take 3 to 4 months to get your registration to you. And if you're trying to submit to, say, film festivals or screenplay competitions, even if you want to go to a producer or a production company, a lot of times they're going to ask you for that copyright information. You go, I haven't gotten it back yet. And I go, well, do you have WGA registration? Yes, I do. I did that as well. So you can, in that interim period, that WGA registration sort of acts as a stopgap measure to allow you to submit your script. If you've already done all your rewrites and you think it's great and it's ready to be sent out, that will allow you to get into festivals, competitions, and even get companies to read your script. And it also shows that you're a professional and that you've done your due diligence, because they're going to do their due diligence and they're not going to look at your script if you don't have it copywritten, or at least show that you started that process by going to the WGA, because they're not going to take a chance. So if you want to play with the big boys, you got to play by their rules, and these rules are there to protect you as well. So get your copyright registration from the U.S. Copyright Office. You probably also want to get the WGA, so that's going to be another $20. So we're talking about $55 if you're going to be submitting to competitions, or you want to start getting it out to producers and production companies before you get that registration from the Copyright Office. Anyway, that's all I have to say about copyright for the moment. If you have any questions, send me an email at william@thescreenwritersjourney.com, or you can use the comment section down below, and I will respond to that. If you know of anybody who has won a court case using the poor man's copyright, let me know, and I will gladly proclaim that to the masses and admit that I was wrong. But I've never been able to find anything on that. I've never talked to a lawyer who has found that to be the case. So it's a myth that needs to be debunked. Anyway, that's it for today. Tomorrow night, I'm going to the IWA-TV workshop to do the latest edition of Everyday Clowns. And for the next 2 Tuesdays after this, I will be up at Tuesdays at 9 with Come Up. So there's going to be a lot of writing and a lot of feedback over the next couple of weeks. So you'll definitely want to check back and find out how that turns out. Until then, keep up the writing and get your copyright.